This is the recording for the topic on membership to accompany the PowerPoint slides which I recently loaded onto the Vula site. It's a very short topic. All I want to do is introduce you to a couple of concepts and definitions which are significant particularly for our forthcoming topic on shareholder remedies. I'm not going to follow the PowerPoint slides exactly because I'm only going to deal with less information than the slides refer to, but what is on this recording is all that you need to know. Firstly, just a few words about definitions and terminology. At common law, we often refer to shareholders of companies as members or shareholders. The two terms were used interchangeably. Just note that the position is slightly different now under the 2008 Companies Act. The Act reserves the term members for non-profit companies only. So the term member is only used by the Act in relation to non-profit companies. We, of course, are primarily concerned with profit companies, and in relation to profit companies, the Act only uses the term shareholder. And now, this term shareholder is defined in Section 1 of the Act as meaning, and I quote, the holder of a share issued by a company and who is entered as such in the certificated or uncertificated securities register as the case may be. Now let me just pause here and explain this reference to certificated and uncertificated securities. You probably did this in the first semester with Jackie. Just to remind you that securities mean shares and other forms of investment instruments in companies, and these securities can be either certificated or they can be uncertificated. Now, certificated securities are being phased out, and they are basically securities that are represented by a physical certificate or a physical document of some sort. Now, that certificate records the number and the type of shares or other instrument that are held, the name of the company in which they are held, and companies are required then to keep a register listing the identity of all of the holders of their certificated securities and certain other information. Uncertificated securities, on the other hand, are not represented by any physical document or certificate. So they're sometimes called paperless shares. Information relating to the holding and relating to the transfer of uncertificated securities is all recorded electronically on a central national database or register. But back to the definition of a shareholder. As I said, a shareholder is defined as the holder of a share, certificated or uncertificated, etc., who is entered as such in the relevant register. Now it's clear from that section that there are two requirements that have to be fulfilled before a person will be recognized as a shareholder of a company. First, they must hold a share in the company, and second, their name must have been entered into the company's securities register. Now that definition of a shareholder is important because most of the Act's provisions, when dealing with obligations of companies and rights of members and so on, gives rights to shareholders and only to shareholders of companies. And a lot of the remedies say that they are available to shareholders. So it's important to know whether a particular individual is a shareholder for various reasons and purposes across the spectrum of the Act. There are some slightly different definitions of a shareholder specifically for particular portions of the Act, but don't be concerned with those now. The general definition for our purposes means any person who holds a share and whose name has been recorded on the relevant company's securities register. A couple of words about the acquisition of shareholdership. A person can become a shareholder in basically one of two ways. Either by way of a subscription for shares, in other words, through an acquisition of new, previously unissued shares from the company itself, and that would be done either upon incorporation of the company or subsequently by entering into a contract of subscription with the company. Alternatively, a person may become a shareholder of a company by way of a transfer of shares. Now, a transfer of shares is basically an acquisition of previously or already issued shares from an existing shareholder, and that would normally be in terms of a contract of sale or pursuant to a will of a deceased shareholder, and so on. Another section that's relevant to the acquisition of shareholding in a company is Section 59. Section 59 refers to something called a record date. Now, the record date is basically the date from which shareholders are formally recognized as shareholders and as having the rights of shareholders. So have a brief look at that section. I'm not particularly concerned with the detail. On the issue of capacity to become a shareholder, just note that being a shareholder entitles one to various rights in relation to the company, in terms of both the common law and in terms of the Act. Now, these rights are legal rights, and so they can only be exercised by persons who have full legal capacity. So it follows from that only legal persons can be shareholders. So, for example, a partnership is not a separate legal person, so a partnership itself could not be a shareholder of a company. The shares would have to be held by the individual partners jointly. Persons who do not have full contractual capacity or full legal capacity, who have restricted legal capacity, would only be able to be shareholders and to exercise particularly the rights of shareholders with the assistance of a legal representative, and that would be the case, for example, in relation to minors. Now, a company, we know, is a separate legal person, so could in principle become a member or a shareholder of another company, and that's exactly how company groups arise. One company becomes a shareholder in another company, which may be its subsidiary, may not be its subsidiary, and that underlying company could itself hold shares in and be a shareholder in another company, and so on. Note, however, a company cannot hold issued shares in itself and can't be a shareholder of itself, and there are also limitations on the ability of a subsidiary company to hold shares in their holding company. But again, presumably you've done all of that stuff in the first semester. Cessation of shareholding, termination of shareholding, that would occur when a shareholder's name is removed from the relevant register, and that may come about in various ways. For example, where they've transferred their shares to someone else, where they have died and their shares have been transferred in terms of their will to somebody else, and so on. Now note, not all shareholders actually beneficially own the shares that are registered in their names. That is because our law permits something called a nominee arrangement. Now, a nominee arrangement is one in terms of which the holder of the actual beneficial interest, what you could call loosely the actual owner, or don't use that, it's not a technical term, but just to give you a sense of the meaning of the actual beneficial owner, has their shares registered in somebody else's name. Now, the person in whose name the shares are registered is called the nominee, and they hold the shares as agent for the beneficial or actual owner. And they get to exercise all of the rights attached to the share, but they have to do so in accordance with the actual beneficial owner's instructions. Now, of the two, the nominee and the actual beneficial owner, it is the nominee that is generally recognized as being the shareholder of the company and as being entitled to enforce all of the rights of shareholders in terms of the common law and in terms of the Act. So it is the nominee who is entitled to, for example, receive notice of general meetings. It is the nominee who is entitled to attend and vote at those general meetings, and so on. The only case where nominee arrangements are not permitted is where the company's MOI contains a provision prohibiting their use. The authority for that is Section 56, subsection 1. There are, however, some disclosure requirements that have to be complied with where nominee relationships exist in relation to shares in public companies. Those are set out in sections 56 sub 3 to sub 7, which you could just have a brief look at, please. The only concern with nominee arrangements is in situations where they may hide takeovers, insider trading, anti-competitive behavior, market control, those sorts of things. But they are catered for by various disclosure requirements in terms of the Act. But generally, nominee arrangements as such are not perceived as wrongful or problematic at all. Again, just a few words about the rights and duties of shareholders. Both the Companies Act, the Common Law, the Companies Constitution all confer various rights and in some cases duties on, but primarily rights on the part of shareholders. The most important significant personal rights for shareholders are firstly the right to receive notice of general meetings, second, the right to participate and vote at those general meetings, third, a right to receive copies of the company's annual financial statements and minutes of general meetings, the right to receive dividends and other distributions from the company if and when declared, because of course we know there is no right to dividends or any other distribution unless and until it has been properly declared. However, there is nothing in our law generally that gives shareholders any management rights. We know from Section 66 that the Act confers exclusive management powers generally on the Board of Directors, and as the Supreme Court of Appeal confirmed in the Klitschko versus Davis case, the citation for which is on the slides, but if you want it now, it's 2005, 3 SA 486, again an SCA judgment, in which the court confirmed, firstly, shareholders do not generally have any right as shareholders to manage the company. Second, as such, they also don't automatically have any right to see minutes of board or management meetings. And third, they do, however, have a right to receive copies of the company's annual financial statements and minutes of general meetings. Now, you may have realized that all of the rights that our law gives to shareholders are essentially rights against or in relation to the company itself. There's no mention of shareholder rights in relation to, for example, other shareholders. And that is because our company law does not generally recognize any kind of personal relationship or any personal rights and duties as between shareholders inter se. The only exceptions to that general principle is where the shareholders have contractually created some kind of special relationship or legal rights or duties with each other by, for example, entering into a shareholders' agreement. And the only other circumstance in which our law really acknowledges the possibility of a legally significant relationship between shareholders personally is where the company is what is referred to as a domestic company. Now, I think I've mentioned the concept of a domestic company to you in the lectures, but in case I haven't or in case you've forgotten, it is basically a company which has all of the following features. Firstly, it's a private company, a relatively small private company with relatively few shareholders. Small company, private company, few shareholders. Second, the shareholders have some kind of pre-existing personal relationship with each other. For example, they may all be friends or members of the same family. Third, that personal relationship is of such a nature that it can be classified as being one of what the courts refer to as mutual trust and confidence. So there's some kind of personal relationship, and it's a relationship of mutual trust and confidence. And fourthly, when the company was first incorporated, there was an understanding between all of the shareholders that each of them would be entitled to be involved in managing the company. In other words, that they would each be directors. Now, where companies have all of those features, they are treated slightly differently by the courts, particularly when it comes to the issue of shareholder remedies and the application and ambit of shareholder remedies. In relation to these domestic companies, the courts basically recognize and acknowledge there is a personal relationship between the shareholders. It is of legal significance, and it needs to be taken into account through, for example, recognizing special rights and remedies as between them. And some authority for that kind of approach is Hewlett and Others versus Hewlett, 1992 4 SA 291, former appellate division case. Again, the citation is on the slides. Few words about registers of members. The Act requires companies to keep certain registers or lists of holders of their securities, and the requirements for the register differ in relation to certificated and uncertificated securities. I've already explained the difference between the two, certificated and uncertificated securities. When it comes to the register requirements, they are to be found in sections 49 and 50 of the Act. And basically, a company must keep a register of the holders of any certificated securities, whereas the register of holders of uncertificated securities is recorded electronically on a central national database called the Central Securities Depository. And then the company's regulations of 2011 contain certain further detailed requirements relating to securities registers and the information they need to contain. And that's all I think you need to know for the purposes of our forthcoming topics.